Okay, here we go.
See that? Very official self-authentication. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Yeah, thank you, and good afternoon, Jonathan Lemons on behalf of the people.
And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready.
Yeah, people are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness, Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn.
I swear our firm testimony you're about to give, the truth of the truth, and nothing but the truth. Please, present the record.
George, I think. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it. With the court's permission, there's a child involved here. I'm just gonna refer to it as the child, so that I'm not putting his name.
That is fine.
And likewise, if defense could. Do you have a son?
Yes, I do.
Okay, and who is the mother of that child?
Defendant.
Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's an white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce, when did that become effective?
2019.
Okay, and as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child
Yes.
in September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes. We each had 50-50 custody, joint custody. And
Okay.
then we did our exchanges on Fridays.
Okay, and so is that one parent would drop them off at school, the other parent would then pick them up?
Yes. You complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay, so I want to fast forward to Thursday of I'm sorry, February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son. And I was contacted by stated they're investigating the claims that she had made against me. They turned out to be false. So I believe it was like the 6th, they contacted me and they said, we're gonna go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay,
He was never returned.
so February 6th of 2023, I believe that was a Monday.
A Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday, so roughly the 3rd. I looked at a calendar earlier.
Yeah, I have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay, go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding the child exchange on the 6th?
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child?
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
Go ahead. Yeah, so had you been kind of monitoring her social media?
Yes, I was concerned that she was going to take out of state.
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to front of work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement in reference to the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return it to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay. All right. The order, when you contacted friend of the court, were you able to receive a copy of the order from friend of the court?
I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1. If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she's
Okay.
trying to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay. Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me back. He called me back.
Okay.
I sent him that document that I had by email, and then he basically said because of the multi-jurisdictional thing that he was going to forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house? Okay. You spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th. Had you receive custody of your child by the 10th?
No.
Okay. Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do, or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore. I
Objection, Your Honor, foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
yes,
What happened as a result of that information?
they submitted another order to the judge. And this was for her, this was terminating her parental rights, and she had until the 24th. It's an ultimatum that she had to return them to front court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes, sir.
Thank you. And if I may approach with people's proposed exhibit number 2. The 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes.
Likewise, did you have an opportunity to view that before testifying in court today?
I have.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
Yes, it was.
Okay. And unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right. So then this order gets signed without telling me what you spoke to. Had you been communicating back and forth with the trooper during this period of time? Okay.
He advised the contact.
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
Keep me updated on status of it.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
No, I sent her a message stating that I was contacting the authorities. She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like the 16th, I think, that week. And they said he was there, that he'd been dropped off. And so I told them that I would be there early, pick him up. And I had no order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay. All right. And that was February, you believe, 16th of 2023, Thursday. Okay. And again, at that point in time, to the best of your knowledge, between February, well, I guess 6th and February 24th. So this is after communicating with CPS to I'm sorry, February 16th. It was the defendant that was the only barrier between you and having custody of your child? Okay. There was no communication that he was missing or anything to that extent. And in fact, had you spoken to your son during that intervening period of time?
Not allowed to have a phone call with him, just the one.
Okay. You had one phone conversation with him? You recognized his voice? Okay. All right. And I guess How old is your child?
He just-
Okay, so he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him,
Yes.
how did you get in contact with him?
We are required to call each other's cell phone.
Okay,
So I call her Alante cell phone.
okay, and so you called the defendant's cell phone and you were able to speak to the son?
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this, witness.
All right. Before you begin cross-examination, I just want to clarify one thing. The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
As I'm reading this,
Go back to 50/50, our regular agreement.
okay,
I think
that's fair. And if I'm counting out the dates, had the child would not have been returned to you really until the 14th, right? If I've got it.
that week. 'Cause I was supposed to have him that first week of the 3rd.
Correct. So you would have the 3rd basically through the 9th.
Yeah.
Right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond,
The 17th.
or the 7th.
Yeah, whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order and I'll let you see it again, the order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on. Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him. He was never returned. I never got him that week at all.
Right.
Yeah.
So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order that it didn't happen. I mean, from the time of these orders, right? 3 or 4 days. Okay. The week then of, oh, let me just stop there for a moment. Because one of the questions the prosecutor asked you then is, on that order, that the child was to remain in your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay, so, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point, not really custody, but possession.
Yeah.
What interrupts that, though, is then the order of the 14th which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it until the court says otherwise. Is that your understanding?
Yes. that's
Okay.
how-
That- Pardon?
That's how Frank explained it to me as well.
I probably did a better job though, right?
He did.
Okay, thank you. All right.
My apologies.
Thank you. No, it's okay. All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I receive the exhibits?
Okay.